according to procedural code and civil code, there are 7 types of evidences in civil trial. First, we're going to discuss about the five first according to 164 HIR, 264 RBG, 1866 Civil Code. Written evidence or in bahasa alat bukti tulisan, witnesses or saksi, inferences or persangkaan, confession or pengakuan, oath or sumpah. And there are two other types of evidences governed by either articles in HIR, which is Article 153 HIR on site examination or in bahasa pemeriksaan setempat, and 154 HIR expertise or in bahasa keterangan ahli. On-site examination and expertise, many scholars believe they cannot be categorized as evidence. Instead, they are only information given before the court. It's different with 164. Those are five evidences are categorized as evidences. We're going to discuss further to check on whether that is correct or not, accordingly to the strength of evidence on each of the evidences. Okay. So the first evidence is written evidence or documentary evidence. So specifically, the umbrella is called as letter. Anything that contains sentences with full stop, with other reading sign, there is an expression of the one who made that kind of letter. It can be categorized as letter as long as there is the expression or the will of the writer. Um, so by saying that, why it is important to distinguish whether a letter categorized as deed or not deed, because each type of letter got different strength of evidence. Okay, so for force of evidence, for example, for acta, acta is a letter that contain legal relation between parties. Since the beginning, parties are agreed to use this letter to be used as evidence before the court, and it is mandatory for a deed to have a signature of the writer, okay, or the parties. It's different with not deed. Not deed is just a letter, content expression or will of the person or the writer. Okay, within deed there are two types of deed. First is authentic deed. Authentic deed is distinguished into two types: amtelijk akte or akte amtelijk and akte partage. Amtelijk akte is officer acte or official acte or deed. It is made by the officer itself, such as when we go to a police station because we lost our wallet, for instance polsek bulak sumur, and the officer in charge will type on and make this letter, what we call as lost letter of lost letter given by the officer. Then we can use the letter to proceed to a bank, for instance, to get a new card. So that is what we call as amtelijk akte. Another type of amtelijk akte is such as your birth certificate made by the civil registry, for instance. And the other types of authentic deed called as partage akte. Partage akte is made by the initiative of the parties in front of the officer, such as when two parties they already made a sales on contract, contract, and they already signed that. However, they think that it is better for them to go before a notary public, and the notary public only got the responsibility for the truth of the parties came, whether the parties came and agreed to register the deed are the correct person. To the content of what they agreed upon, it's up to the parties, and then when it comes to examination before court, about the truth of the content is lie on behalf of the parties. It's different with amtelijk akte, as I first mentioned. For amtelijk akte, the officer who made such akte are responsible to the content that she or he wrote. Okay? So as I already mentioned a bit, there is what we call as partage acte, types of authentic acte, which is came from what we call of private acte, okay? Or akta bawah tangan in bahasa. Akta bawah tangan or private deed is made by the parties without the presence or without the authority of officer. Okay? Parties want to do sell and purchase, it is okay for them to make contract by their own. It is valid as long as fulfill Article 1320 Civil Code. However, if they want to use it, for instance, for evidence in the future, for instance, they could make it into authentic deed. And for a specific types of sales and purchase, they have to do it before notary public, such as for land, for instance, or house leasing or types of that, which has already been promulgated by the law. It is mandated it is obligatory to have a notary public deed. So other than that, we can make contract by our own, categorized as private deed. So by distinguish clearly different types of deeds, we can decipher what types of strength on each type of deed. As for the umbrella letter, typically letter, if it is not deed, the strength of evidence is flexible. It's different with deed. If it is authentic deed, it is complete and binding. Okay? But still open the possibility of counter evidence, of course, or challenge from the other party. But the content is valid and bind the judge unless proven otherwise. It's quite the same with private deed or akta bawah tangan. The difference is private deed is also complete and binding as long as the content and the signature of the parties are recognized and accepted by parties. Okay? As long as there is no objection to the content and the signature there in the deed, then it is complete and binding. So those are for documentary evidence. The important things to know what are the types. After to know the types, and then we can determine the strength of deed or not deed or just a letter accordingly to our evidentiary rule.